videos because the public expects to see them.
Right. I mean, certainly I would think these suspects, if they are caught, cannot argue that it was not them because the images are so clear of their faces, right? And in addition, I mean, it's something like this. I mean, it's a robbery, obviously armed robbery. It doesn't seem like anyone was injured. I think someone was treated for minor injuries. Is this something that you would see even going to trial down the road?
Well, it depends. Personally, I think that, you know, in my experience, now here in Florida, things differ from state to state for practice and procedure, but prosecutions are pretty much the same across the board because of the Constitution. And so what I would typically assume from a case like this where you have such great clear-cut evidence is that you're going to get some kind of plea deal. You won't really see a trial in something like this.
Yeah. Well, we will have to keep an eye on it. Actually, that robbery happened back on July 14th. As Anthony said, the video was just recently released by Los Angeles police, and I would imagine they would likely get some tips from that because the video is so clear. Vincent Hill is now also joining us live via Skype. Our very own Vincent Hill. Are you there, Vincent?
I am, Stacey. How are you?
Oh, good, thanks. So before we move on to our next story, I wanted to get your thoughts on that video. As Krisanne says, I mean, a clear, crystal clear video like this, you know, actually shows the smoking gun and obviously is a real boon to prosecutors' case.
Yeah, absolutely. And as an investigator, those are the types of videos you want. I mean, everything was there. It was crystal clear. Thankfully, we're not dealing with surveillance footage from 20, 30 years ago where it was just this grainy image. I mean, most businesses, as you can see there on your screen, have very crystal clear surveillance equipment, which is capturing, which led to these arrests here. I think it's great. And then when this goes to trial, I mean, how do you argue that? What do you say? It wasn't me. Yes, it was, unless you have a twin brother, of course.
Right. And, you know, as Krisanne said, who knows if this would even get to trial. So we're going to leave it at that with this one. We'll keep an eye on it, though, and it will be interesting to see whether this does speed it up for police in terms of apprehending these suspects. Well, now let's go to big news out of the Washington, D.C. area, out of Virginia. Paul Manafort trial continues today. Today, the defense rested without calling any witnesses. Of course, Manafort facing 32 counts in federal court. Prosecutors say he evaded taxes on millions of dollars of income that he earned working for pro-Russian political forces in Ukraine. Throughout this trial, they have tried to paint him as a man who lied, who applied for fake loans, who basically built this whole scheme to defraud the government of millions and millions of tax dollars. His attorneys, though, seeking really to put this on his right-hand man, his assistant, someone who worked with him closely for years, Rick Gates. So let me first start with you, Krisanne. What can we make of defense attorneys declining to call any witnesses?
In my experience, there's two things going on. Either they feel that the prosecution's case is so bad they don't really have to do much work to it, or that they're not really, in light of the fact that the prosecution's case is so bad, they're not really disputing a lot of the, primary facts, because I think we have a really good indication that the judge has not been happy with the prosecution in this case. And the defense counsel will quite often do things to not actually do damage to the case when they feel like this is really going in their way.
Vincent, do you think there's any harm in the defense not calling any witnesses?
Yeah, I think there's huge harm anytime a defense doesn't call any witnesses, no matter what kind of case it is. I mean, he's facing 30-plus counts. These are some pretty serious charges outside of his tie being crooked, and a lot of those pictures, there's some serious stuff going on here. So if I was a defense attorney, I would be calling some witnesses there to the scene to the courthouse in this trial to, plead my case. But this didn't happen here. We don't know why, but if it was me, I would want that to be taking place in that courtroom.
Right. Well, obviously, Manafort himself has declined to testify. He told the judge he did not want to testify. Any surprise there, Krisanne? I mean, did anyone think really that he might take the stand in his own defense?
Well, that's always something that we consider as a prosecutor, and we have to remember that the burden of proof is on the prosecution. So the prosecution must prove beyond a reasonable doubt. And a lot of times, like I said, everybody would like to see testimony from the defendant. Everybody would like to see defense witnesses. But a lot of times there's this strategic thing that they do where they don't do that. Now, what will happen is during closing arguments, the defense will address this issue and say, look, we realize that you want to see this, but he has a right to not testify. You recognize that by Constitution he does not have to testify. And you realize, in closing arguments, they're going to say, you realize the burden of proof is on the prosecution to prove his guilt beyond a reasonable doubt. And then they'll likely go into great detail as to how the prosecution has failed to meet this burden.
Right. And we'll have to see whether or not the jury agrees whether or not the prosecution has made their case. Well, it seems that we will have closing arguments starting tomorrow morning in the Manafort case. We're going to take a quick break. We'll be back with much more on today's Top Stories. George Burch on the stand in his own defense being cross-examined in this trial. I have two live guests with me this afternoon. Krisanne Hall is a former prosecutor who is joining us live from the Jacksonville, Florida area, and our own Vincent Hill, law enforcement expert, with us via Skype from Atlanta. So we hear this exchange between George Burch and prosecutors, and he's giving answers like, I'm sorry, you're asking a question or making a statement? And he's saying things like, sir, I don't know where I was, right? He's got a bit of a tone there. Krisanne, I'll start with you. Is that helping his case at all?
Well, I think that there's an issue here. He's being calm. He's responding consistently. The prosecutor is not asking questions the way he ought to be asking questions. He is making statements. And I think what we have is a situation here where we're watching a piece of what's going on, and it's difficult to make an assessment from just a piece. The entire testimony is what the jury will see and make their opinion about it. From this piece, though, however, I don't think that he's being evasive. But we do have a lot of positive statement testimony coming, or positive statements rather than questions coming from the prosecutors, which is sometimes typical of how cross-examination works.
Vincent, do you agree with Krisanne's assessment there that the prosecutors are making statements, not asking questions, not maybe being that clear in their line of questioning?
Yeah, absolutely. Krisanne is dead on. And here's the thing, right? George Burch is not his first rodeo, so he knows he can use that to his advantage. If you're making a statement to me, my response would likely be, well, if you say so. But if you ask me a question, then you tie my hands to actually have to answer that question. Even if I say, I don't know, I don't remember, at least you're asking me a question. But if you make a statement to say, well, you took a left, right? Well, if you say so, because you're saying this is what you're telling the jury, that I made a left. I never said that. You're saying that. So I think Krisanne is dead on here.
In a case like this, where George Burch and his attorneys are trying to point the finger at Nicole's boyfriend, Douglas Dietrich, essentially saying that he was having consensual sex with Vanderheyden when Dietrich came outside, found them in the act, got into a jealous rage, killed Nicole, and forced Burch at gunpoint to drive to a rural area and ditch the body. When you have a really intricate story like this, is it in his favor then to take the stand and explain this in his own words, what he claims happened? What do you think, Vincent?
Well, if he's trying to stick to that story, then absolutely. But as a juror, more importantly, as a 45-year-old man, trust me, if I come home and there's a guy in my driveway having sex with my girlfriend, my wife, fiance, whatever she is, she's not going to be the person that ends up in a ditch somewhere. It's going to be the other guy. So, I think it behooved him to take the stand here to try to get the jury to believe this story. But the problem is, it's just not believable, in my opinion.
Krisanne, what do you think?
I think that he has to take the stand because there's conflicting stories here. If I'm not mistaken, I believe there's testimony that the boyfriend was previously abusive. And so he needs to take the stand to present himself as this calm and collected individual so that his defense attorneys can highlight the fact that there has been testimony that the boyfriend was abusive. And just like we saw we're seeing now more often in America, the technology ruling this case. So we have a Fitbit technology that really the defense has to overcome in this. I find it interesting because in the Supreme Court recently handling the U.S. v. Carpenter case, where Justice Gorsuch comes out and says, look, we're going to have to deal with this as the courts, as technology becomes more and more prevalent in America. So what you really have here is a third witness that cannot be cross-examined, which is this Fitbit data. And so he has to overcome this unquestionable witness, and he has to present himself as a calm and collected person, as juxtaposition the boyfriend who will be presented by the defense as someone who is violent.
Yeah, I mean, to your points, yeah, let's talk about that Fitbit in a moment. Nicole and Douglas Dietrich, I think, had argued a lot. There were text messages. They were fighting. They were angry at each other. It did not necessarily come out that he had assaulted her, though he was charged with assaulting her sister after the trial, which is a whole other thing. But yeah, Douglas Dietrich was originally charged with murder in this case. They arrested him first, but because of that Fitbit data, the charges were dropped, and they ultimately arrested George Burch. They were able to link him to the crime, as you say. So it is interesting because you have this Fitbit data. The question is, how much, can you rely on it? And that's something that's been part of this trial all along. How reliable can this really be? Vincent, some people might be surprised to know that, the Fitbit or this Apple Watch, whatever you're wearing on your wrist, could actually accurately pinpoint your location at all times.
Yeah, I mean, that's the thing about modern technology, right? We all wanted it, but it can always come back to bite you if need be, or in this case, help you. Like, I have an Alexa right here in my apartment where I am right now, and as soon as she hears the word, something that sounds like that, she's listening. So there's always something listening. There's always some technology. But the great thing about this, it's great to have technology, but it's even better to have DNA. You cannot dispute DNA. You can dispute technology all you want, but DNA is only going to match to one person, and that's what led them to George Burch in this case. Yeah. It's quite simple.
Yep. All right. Well, listen, let's now revisit, some of the prosecution's closing argument in this case, because we do want to make sure we get to the verdict this afternoon, and there's still a lot more to cover before we get to that. So let's go ahead and listen to how they started off their closing arguments. Well, there you have it, just a snippet of the prosecutor's opening statement from this morning in Shayna Huber's retrial. With me live this afternoon are Krisanne Hall, former prosecutor who joins us live via Skype, and Law&Crime host and law enforcement expert Vincent Hill, also with us via Skype. So what can we make of this first little snippet of the prosecutor's opening statement? The allegation here is that she killed her boyfriend, that she murdered him, that basically, if he couldn't be hers, if she couldn't have him, no one else could. And we hear the prosecutor talk about how she fired 6 shots into him. The first one made him squirm, and because she was uncomfortable, she fired 5 more to put him out of his misery. So, Krisanne, what do you make of that?
Well, what the prosecution is doing here is proving intent. So they have to dispute this victim woman fighting for her life in the heat of the moment testimony with showing the facts from her own testimony that she actually was calm and collected, and that she made a secondary decision. So even if her first, they can argue that her first shot was not what was in self-defense, then the point at which she made a second conscious decision to say, no, I'm going to kill him, is where the intent comes in for your premeditated murder.
Right. After that first shot, presumably if this was self-defense, she could have quickly called 911 help. Vincent, do you agree with Krisanne?
Yeah, I agree, because let's be clear here. Self-defense, yes. If there was a first shot and then he retreated like I'm sure he would if he was shot. Most people just don't bounce back from being shot or continue unless they're under the influence of some type of narcotic or something like that. But to shoot him 5 additional times, and the one in the face, tells me that I think this was premeditated. It was planned. She reminds me of a young lady that we know as Jodi Arias, right? she started playing the victim and started blaming things on Travis Alexander. You know, he wanted to take these types of pictures. He wanted me to do this sexually. She's using this defense. It was self-defense. I was abused. But 6 shots, 1 to the face, which is definitely a kill shot. It's hard for me to articulate as an investigator self-defense.
Yeah, you know, before we hear some of what the defense said in their opening argument, as they paint this to be, try to paint this to be a picture of self-defense, her being terrified when she claims that he lunged at her. Let's just talk about the first verdict getting overturned here, because Krisanne, a lot of people are surprised. Really, they found out years later that there was a convicted felon on the jury. How did no one know that? You have to fill out paperwork, right? But in this case, you say it's actually not that surprising because the person didn't even consider themselves to be a convicted felon.
Yeah, so what we have is a situation here where the juror was not he didn't get convicted of robbery or murder or any kind of violent assault. His crime was a failure to pay child support in a timely manner. And he never went to jail. He probably had all of that handled right there in the courtroom, and he made a plea deal. Hey, you pay your child support and we won't put you in jail. And a lot of times when these things happen, people don't realize that they've actually become felons. And this is unfortunately something that we're seeing in America, this over-criminalization of what or overcharging of things which should be not felonies. Plus you have a situation where people who are nonviolent felons are having their civil and natural rights taken from them for life.
The background investigation that took place during the original trial, that's where the problem lies.
Yeah. Well, as we've been saying, defense here says this shooting was in self-defense. There wasn't intent. They are hoping to do better, obviously, this time around in this second take, the retrial. Let's now listen to some of the defense's opening arguments. Well, I can tell you our Aaron Keller in that courtroom says the defense basically wrapped up their opening statement saying, we believe the evidence will show Hubers is not guilty of the crime because she was acting under extreme emotional distress. Krisanne and Vincent, how much has Shayna Hubers hurt her own case up to this point in the 6 years that it's been going? We know that we will hear a prison interview with her. We know police said she didn't seem very upset when they initially interviewed her after. She talks and talks. Is that going to hurt her in the second go-around? What do you think, Krisanne?
You know, as a lawyer, one of our biggest fears is a client who will not be quiet. And I mean, it's one thing to have a case where you have a difficult situation to prove the innocence of your client, but then it's another thing you have to turn around and then undo all the things that she's done. And that's why this is not a good case for them. All things set aside, a retrial is a benefit for the defense because now they've seen all of the prosecution's case. They've seen everything, how it's going to line out. And so now it's like they get a second bite at the same apple. They get to go forward. But they've got a lot to overcome.
For sure. Quick break. When we come back, much more on Shayna Hubers and the George Burch trial out of Wisconsin. Stick around. We're just going to take a quick break. We'll be right back here on Law&Crime.
I'm Amy Dash, anchor at the Law&Crime Network. People are always asking me, why did you leave your law job to be a legal reporter? And I say, stop, let's rewind and flip that script, because I went to law school to be a legal correspondent so that I could explain the law in a way that anyone can understand it.
Can the imminent threat be something that has built over time, or does it have to be an imminent threat that exists at that very moment that he goes out and shoots to kill?
It's got to be imminent.
What I love about the Law&Crime Network is we're not just covering trials, we are examining justice so that the public can question it and help shape it. And through that coverage, I get to take the law and bring it down to earth for you. And that is truly an honor.
Hey everyone, I'm Jesse Weber, and this is more legal news you can use.
Today's topic centers around an all too familiar one, drunk driving. You're out, have a few drinks, get behind the wheel of your car, and then are pulled over by the police. So the question is, are you required to perform field sobriety tests? Let's break it down. There are a number of tests an officer can ask you to perform to determine how drunk you are, but the three big ones are the following. The HGN test. Officer observes how your eyes move as they follow a pen or flashlight. Walk and turn test. You would walk in a straight line, touching heel to toe, then turn around on one foot and walk back the same way. One leg stand test. You stand on one foot and count aloud. Now, by law, you don't actually have to perform field sobriety tests. That's right, you can refuse to take them. The same is true for a breathalyzer test, which measures blood alcohol concentration. However, even if you don't take the tests, officers can still arrest you if they have enough probable cause to believe your driving is impaired. Also, in many states, simply refusing to a breathalyzer test can result in a 6 to 12-month automatic suspension of your license, fines, and maybe even jail time if you have past DUI convictions. Bet many of you didn't know that. One more quick thing. Blood tests. Unless police have a warrant, you cannot be punished for refusing a blood test during a DUI arrest. But the most important thing, ladies and gentlemen, to avoid all of this, do not get behind the wheel of the car if you have been drinking. Go to lawandcrime.com for more legal news you can use.
I'm Rachel Stockman for Law and Crime, and here in Law and Crime, we love bringing you inside the courtroom action because it's so important for the public to see how our justice system works. Plus, you never know what's going to happen when the cameras are rolling.
Welcome back to Law and Crime. I'm Stacey Delikat, and thanks again for hanging out with us on this Thursday afternoon. We've been talking about the Shayna Hubers trial, which got underway today in Kentucky. We're going to take a quick break from that. Remember, our own Aaron Keller is in the courtroom. He will be bringing us updates when he can, but the judge not allowing live streaming in that trial. So in the meantime, we are revisiting the case of George Burch, who's was on trial for murdering Nicole Vanderhayden, a woman he met in a bar in Wisconsin in the Green Bay area. Prosecutors say that he violently strangled Nicole to death after sexually assaulting her, then ditched her body in a rural area. But he and his defense attorneys are pointing the finger at Nicole's boyfriend, Douglas Dietrich. They say Dietrich caught Nicole and George in the act, having sex late at night. He flew into a violent rage, killed Nicole, then ordered George to help him ditch the body. A bit of an unbelievable tale, but obviously George Burch and his attorneys believe they have a chance at getting jurors to believe it. So when we last left off, we had heard from George Burch on the stand himself, and then we heard the very beginning of the prosecution's closing argument. So let's go ahead and pick up where we left off.
Checking routinely, regularly, and not looking for anything else. How many accounts did you hear of on that forensic search of his phone? He's worried about being discovered. You learned about that, and that's further proof of his involvement in committing this crime. And all this evidence is undisputed. In the opening, the defense told you it was his phone. He was at those locations. It is his DNA. This isn't even something we need to argue about because it's uncontradicted. The defense told you. They agreed with the state's evidence, most of the state's evidence. They told you it would come down to argument. Well, we say it comes down to logic and common sense, not argument. They cannot erase our evidence. Now the defendant has to try to come up with an explanation for all this evidence. Find a way to explain it to you. He needs an explanation for all the physical and scientific evidence that shows that he's a killer. Their explanation is ridiculous and it's insulting to your intelligence. They offer distractions, but worse, they offer testimony of the defendant. Such arrogance. He meets Nikki at Richard Cranium's. He's a stranger. He doesn't know her. What's he tell you? She's flirting with him. What's he say? You can tell when someone's into you. Clearly, this 6'7" hunk of man could not be resisted. You saw his picture. What was a girl to do? What were Nikki's choices? He told you she didn't seem to be with anyone. She was by herself. He saw her as prey, somebody to move in on. He had one thing in mind, and it was not giving her a ride home. Think about it. They both wanted consensual sex. They would have gone to his house, to his home, where he had a room, 2.5 blocks, he says, from Richard Cranium's, where he had privacy, where he was allowed to bring home women and did it on other occasions. Oh, but no, there was an elderly gentleman in the house at the time in the living room. That makes no sense. But no, they don't have sex there. They don't go to a hotel. No, it's on to Berkeley. And she obviously had to tell him how to get there. He didn't know where it was. She obviously gave him directions because she thought he was taking her home. To her child. To the father of her child. To her home. And that's also, when you get to Berkeley, how we know the defendant's lying when he testified. Because what did he tell you that Nikki said? He claimed Nicole told him there was a light on and the babysitter was there. Nicole would never have made that statement. There was no car in the driveway or in the street. Dallas's vehicle was not there. Nikki would have not said, oh, the babysitter's still there. Dallas testified she'd gone already. She left around 3 a.m., right before they got there. There was no vehicle to be seen. She's friends with Dallas. She knew her car. She would never have said, oh, the babysitter's here. There's a light on. She would have seen the car was gone, and she would probably assumed that Doug was home. He makes this statement up. He makes up this account. This whole thing is made up. And that statement there points out that Nikki didn't say that because none of this happened. He tries to make you believe this encounter was consensual as far as sexual activity. Killing her is not enough. He seeks to defame her. Her life's gone, so let's go after her reputation. She's not here to counter these outrageous claims. That's very convenient for him. Infidelity. What, revenge sex? He calls it wasn't gentle intercourse. So now we're supposed to believe this stay-home mom, this part-time substitute teacher, is into rough sex with a stranger. He has no shame. What really happened? Evaluate the proof. What happened, do we know, to this poor woman's person and her private areas? Contusions, abrasions, vaginal vault blood presence. And think about this. The doctor told you this wasn't just from stomping, this was internal injuries as well. Penetration took place. Consider the vaginal area. This woman was in a relationship with a man. She'd borne 3 children. The vaginal area is an area designed for penetration. People around the world have sexual intercourse, and we don't have abrasions and contusions and bleeding. This was forcible. This was painful. The doctor told you that. But the defendant can't admit that because it's his motive for the murder. You don't need a medical degree to draw the same conclusion Dr. Ogalska did, that this was suggestive of a sexual assault. The evidence and the injuries suggestive of a sexual assault. This was a forcible penetration. It would have been a painful penetration. It was a rape. But aside from all these horrible injuries, which are horrible, with respect to just that area of her person, practically speaking, ladies and gentlemen, I know you use your common sense. Why do we know that she did not choose to have sex with this defendant? It's because of the location. It's like real estate. It's all about the location. You're not going to have sex in front of your neighbor's house and near your own home, where your father...
Well, some more of the prosecutor's closing arguments in the murder case against George Burch, and there we start to hear the really disturbing details that came out during this trial about the injuries which medical examiners found after the fact, which suggests that this was in fact sexual assault. Krisanne Hall, former prosecutor, and Vincent Hill, law enforcement expert, still with me. When we hear these details, they're kind of hard to hear about, you know, the bruises, the abrasions. The prosecutor said, I mean, people all over the world have sex, they don't wind up with these injuries. It's hard to hear, right? And I imagine that does sway the jury, right, Vincent?
Oh, yeah, absolutely. Anytime you're talking such graphic details of something that not only was she killed, I mean, let's look at what clearly happened before she was killed. That's playing heavily on the jurors, whether they're male or female.
Vincent, I have to cut you off. I forgot we have to take a quick break. I know you have to sign off. Thanks for being with us. We'll be right back.